Okay, good afternoon, everyone. ठीक है. Okay, so just towards starting up a little bit of a topic which I can probably finish in the next 2 hours, I want to introduce the concept of quasi-judicial bodies. When you think about quasi-judicial bodies, we are thinking about uh, one thing that we have to cover, which is tribunals. I'm not going to define quasi-judicial bodies right now, but while we are in the middle of covering the concept of tribunals, we will have to take a look at, we will understand the quasi-judicial concept of the quasi-judicial bodies, etc. Okay. So the point of tribunals, I'm going to take categorically each and every point till the time that we have to cover a current affair of it. Okay. So let me just draw a synopsis of how we will take a look at tribunals right now. And I intend to finish this part by the end of this class today so that we have covered another major important part and freed up our energies for covering the remaining parts quickly in the session tomorrow. Okay. In tribunals, first thing that we take a look at is a historical background. Okay. Historical background within tribunals. With regard to the historical background, we'll take a look at the original constitution. B, the, let's say, what is known as the 76th Constitution Amendment Act, 42nd Constitution Amendment Act 1976, which is the provision of Article 323A and 323B. This is how the tribunals were introduced into the Constitution. Then we take a look at the next part, which is the judicial interpretations. As to how the judiciary has interpreted the tribunals. Okay, and then we take a look at point number D, which is about current updates. For example, in current updates, we'll take a look at one part of tribunals is the Tribunal Reform Act 2021, which is pending before the Supreme Court under the question of constitutionality. Right? And the second part is what we'll take a look at is National Tribunals Commission, what is also known as the NTC. Right? So this is a bit of a synopsis of what we will cover in tribunals. In fact, just remove this part as historical background. Just write tribunals over here. We'll cover it into 4 points. Point A, original constitution, 42nd Constitution Amendment Act 1976, Article 323A and B, judicial review and interpretation, and current updates. Tribunal Reform Act 2021 pending before the Supreme Court, and National Tribunals Commission, NTC. Okay? Okay? Chalo, let's begin. Now, if we talk about the first part, let's say, the first part, which is what is the original constitution? Okay, I'm going to explain almost everything with regard to tribunals today. So just be with me and make sure that this becomes the final and decisive lecture that you take in understanding the question of tribunals for all times to come. Okay. So, for example, we're taking a look at original constitution. The point that we mentioned first is that there was no such thing as a tribunal. No provision for tribunals. Okay, tribunals were not included as a part of the original constitution. Okay, there was only one mention of the tribunal as a concept, which is under Article 136. Article 136 of the Constitution, which talks about special leave to appeal, or what is known as a special leave petition, SLP. It was the only place it was mentioned that the Supreme Court can hear an appeal directly from any court in India, including a tribunal. Right? So this was the only place where the concept of tribunal was actually mentioned in the Constitution of India. Okay, in the original constitution, there was no provision for having a tribunal kind of a body. Okay, because in the original constitution, the judicial powers, which is, for example, what does the judiciary do in terms of exercising its power? It is a judicial body, which implies that it is a body which gives judgments, which adjudicates upon matters, which interprets law and enforces law in certain cases, and it also allows the whole idea of a court procedure to run out in senses, which means that it is an adjudicatory body which is responsible for judgments and decisions and arguments and all of these things, right? So these judicial functions were exclusively given to the courts in India. All the judicial functions were given to the organ of the state known as to the judiciary exclusively. There was no such mention of judicial functions in the original draft of the Constitution. There was no such mention of the judicial functions in the original draft of the Constitution. That's the part which you're taking a look at. Only apart from a kind of a brief peripheral mention under Article 136 of the Constitution. So it was not in the vision of the Constitution makers to institute something like a tribunal. For example, today you see many tribunals. Every day in the news you see about debt recovery tribunal, insolvency tribunal, national income tax tribunal, the companies law tribunal, NCLT, NCLAT, etc. All these tribunals and appellate tribunals have become a very specific and a very, what you can call, a very popular part of the Indian judicial system, but it was not the case in the original constitution at all. Okay, why was the need felt to make tribunals a kind of a situation? Okay, so we take a look at how this kind of a thing developed. Now, when the Indian judiciary, especially for example the High Court and the Supreme Court, when we talk about the like let's say the story of High Court and the Supreme Court in India, what we are seeing is that the as put it on a timeline like x-axis, as for example the High Court and the Supreme Court moved from 1950 to 1960 to 1970, right? What you see is, let's say for example, if on a y-axis I put, let's say, a pendency. This is the key term, pendency. Okay, so if I plot a graph over here, let's say for example, if I denote pendency by 5, by 10, by 15, by 16, by 20, by 25. If I do this kind of a denotation, then what I see is that pendency had grown significantly with time. If you take till the middle of 1970s and 80s, this is a kind of a curve that the whole idea of pendency has taken. You see, it's upwards and onwards as to what is the pendency which was being created before the Supreme Court and the High Court. Constantly, a lot of cases were getting piled up, right? The phenomenon is known as piling up. So more and more cases were there with the High Court and the Supreme Court of India, and the High Court and the Supreme Court for India felt overwhelmed in terms of disposing these cases. Okay, they were, the High Court and the Supreme Court felt a sense of what you call a clear understanding that they were not able to maintain a balance in terms of finding a way to deal with these kind of situations and cases. Right. So the question of creating what is known as an alternate judicial bodies, this started becoming a little bit of a relevant. Alternate judicial bodies, especially at the level of the High Court, this started becoming a relevant question, which means that there have to be other judicial bodies which can be created, which can substitute the High Court, which can stand in the place of the High Court, which can be as good as a High Court, right? Alternate judicial bodies to lower the burden of the High Court, and these certain matters can be taken from the High Court to these alternate judicial bodies. So the idea of a tribunal always existed like that. For example, you have tribunals which are, let's say, judicial bodies which have judicial functions and judicial powers, and they can perform these activities as good as a High Court can. So this idea was there, but this idea started gaining currency as the High Court and the Supreme Court started faltering in terms of the pendency they had taken it. Okay, and there were many reports. For example, you had the Law Commission reports. Many Law Commission reports had talked about the problem of pendency. Jawaharlal Nehru himself, in many times, has stood up before the Parliament and told the people of India that the Supreme Court and High Court are unable to dispose many cases, and therefore there is a lot of pendency of cases, and we are looking at a problem which is coming at us from all directions, that the judicial bodies in this country are not able to perform as specifically as they could have been required, right? So the question was about pendency and the associations which were coming along with that. So it was eventually in the 1970s that this kind of a thing was taken aggressively by the Indira Gandhi government, and you had, for example, in 1970s, when the Indira Gandhi government was in power, Indira Gandhi government appointed a committee by the name of Swaran Singh Committee. Okay, it was a Swaran Singh Committee which was supposed to give recommendations to amend the constitution, right? So the 42nd Constitution Amendment Act, which I'm sure all of you have very clear understanding of, the 42nd Constitution Amendment Act 1976, which had brought significant changes to the draft of the constitution, was actually introduced by the Swaran Singh Committee in 1976. Right? On the recommendations of the Swaran Singh Committee, it was introduced in 1976. Okay, so what you see is the fact that Swaran Singh Committee, within its framework, had for the first time advocated for a system of tribunals. Okay, he said that tribunals must be introduced in the constitution for this kind of an idea, that they should, to solve the problem of the pendency of cases and to create alternate judicial bodies, you have to create tribunals, because the High Court and the Supreme Court are unable to deal with the pressures that they are facing with regard to the number of cases that they are remaining undisposed in both these courts, the High Court and the Supreme Court of India. Okay, so with this reference, the government had introduced a provision for amending the constitution and to introduce the concept of tribunals in the Constitution of India. Right after the 42nd Amendment Act was passed in 1976, you had the articles given under Article 323A plus B, which gave a constitutional position to tribunals. Right, so this was the time when this kind of a thing was introduced. But also, while I'm mentioning this kind of a descriptive history of tribunals in India, a lot of things are happening in the background of why this kind of a thing was coming together. One of them was that by the mid of the 1970s, you see, mid of the 1970s, if I change this graph a little bit, and instead of pendency, I give it a different connotation. Okay, it was government versus the judiciary. Okay, the government versus judiciary kind of a thing was also getting, the competition or rivalry between the government and the judiciary was also on an upscale, right? So let me, for example, if I have to draw a map over here indicating how Indian government and Indian judiciary have fared with each other, you have something like this. You see, in 1950, government and judiciary were at the same page. In 1960, more or less the same page, some divergences. The main divergence came between the government and the judiciary somewhere in 1967 with the Golaknath case. And then the divergences came even more significantly in 1973 with the Keshwananda Bharati case. And then you had, some amount of, let's say, dip where the judiciary had started leaning towards the government of India in ADM Jabalpur case. But then again, you had divergences between judiciary in Maneka Gandhi case and the Minerva Mills case, right? So the 1970s, this period, okay, this bracket period, this was a period of the height of the contestation between the judiciary and the government. Right? Now you see what I'm plotting over here, right? These are individual case laws which can be plotted in this regard. Okay, so for example, in 1950 you have the Shankari Prasad judgment, which is very favorable for the government. 1960 you have the Sajjan Singh government, again favorable for the government. But in 1967 over here you have the Golaknath judgment, in which the problem between the judiciary and the government starts rising, right? And then you have, of course, the most important judgment in the history of India, which is the Keshwananda Bharati judgment, 1976, right? And then you have the ADM Jabalpur judgment, and then you have the Minerva Mills judgment, and then you have the Maneka Gandhi judgment, right? So these are areas in which the government had started very heavily antagonizing the judiciary, especially after the Keshwananda Bharati judgment and the invention of the basic structure doctrine. Right? You have the Keshwananda Bharati judgment and you have the invention of the basic structure doctrine, under which the concept of judicial review In the Keshavananda Bharati judgment, you have the basic structure doctrine under which the concept of judicial review has been taken to magnificent proportions by the Supreme Court, right? The Supreme Court has expanded the concept of judicial review to totally gigantic proportions in that sense, increasing heavily its own power to strike down laws as unconstitutional. This became the high point of the difference between the government and the, what you call, sorry, Keshavananda Bharati judgment. It's 1973, I'm sorry, not 1976. This became the high point of the dispute between the government of India and the judiciary. So the fact that the 22nd Constitution, 42nd Constitution Amendment Act, which was brought about in 1976, was a kind of a response by the government of India against a lot of things which were happening with regard to judiciary taking more and more power away from the government of India. So by the Keshavananda Bharati judgment, of course, the idea was the judiciary had said that there is no such thing as infinite powers of the parliament to amend the constitution. Therefore, the parliament can only have limited powers, and that is also determined and subjected by the basic structure doctrine, which means that the basic structure of the constitution cannot be altered by the parliament, cannot be, in a way, taken and divided by the parliament. Right? So what we are looking at is a antagonism, and therefore one of the aspects of 42nd Constitution Amendment Act was to introduce bodies as an alternate to the judiciary. So judiciary, where it was getting more and more powerful, the parliament, the government wanted to introduce a body structure which was, number one, taking away the powers from the judiciary. Number two, was directly under the control of the government of India, because judiciary was more and more getting outside the control of government of India, right? You had now in some time later seen some cases, for example, the first and the second and the third judges cases by which the collegium system was formed. So judiciary was not very comfortable with remaining under the control of the government of India in any sense whatsoever. Right? Now take a look at this. If, let's say, for example, if this is this structure that I create over here, this is the whole volume of the judicial functions of India. Okay. This is, let's say, for example, this is all the subject matters of which you have judicial functions, right? What the 42nd Constitution Amendment Act did was that the act cut out so many portions or segments which were previously under the judiciary, which means the Supreme Court and the High Court, and gave it all to an alternate judicial system, which was by the name of tribunals. Okay. Now judiciary has, after this entire thing, secured considerable independence from the executive, meaning the executive cannot have a control over what the judiciary does, and later on executive cannot even appoint the judges. The judges are going to be appointed by the judges themselves. So independence from executive was something which was fundamentally given as a part in the judicial framework. But tribunals, as they were created under Article 323A and B, they inherently were coming under the control and supervision of the government of India. You see, so in a way, the attempt to create Article 323A plus B has two explanations to it. One is the fact that the judiciary faltered at the level of not having to be, not have been able to create a proper framework in which it could have disposed of the pendency of cases. Okay, that there were certain ways in which the judiciary was unable to dispose the pendency of cases. So there was a need for an alternate judicial body, that's correct. But at the same time, the political timing of it was quite significant. 1976, just years after the basic structure doctrine, and when the judiciary had started taking more power, the idea was now to take all the judicial functions of judiciary and cut it into half and give half of them to tribunals and make the government of India in response to tribunals. So this was done by a Constitution Amendment Act to introduce Article 323A plus B within the Constitution. You see, so this kind of a birth of the tribunal system has a legitimate reform in mind, but also we very clearly understand that the tussle of the judiciary with the government is already reflected in the structuring of the tribunals, and this tussle is continuing even till today. Recently also, you have, if you have been reading the news, you've been seeing a lot of anger from the judiciary about the tribunals and Tribunal Reforms Act and appointment of members of tribunal and independence of judiciary and whatnot. These are things which have been raised as very proper issues by the government, by the judiciary before the government of India. Right? So that's the kind of part and aspects which we are taking a look at in covering this range of things about the tribunals, right? So little bit of what you can call historical background with regard to the original constitution. What was the vision of the tribunals? Okay, so just please, before we move forward into reading article 42nd constitution amendment, article 323A and B, let us just first give a brief write up to this part of the original constitution. Please write down whatever I've explained to you. I'll make you write it now. Please write down in point number A over here, original constitution. Okay, original constitution, write down. The original constitution of 1949, original constitution of 1949, the original constitution of 1949, original constitution of 1949 did not provide did not provide did not provide for the constitution of tribunals, the constitution of tribunals, comma, all the judicial functions of the state, all the judicial functions of the state were exclusively were exclusively were exclusively reserved for the judiciary, reserved for the judiciary. All the exclusive functions, all the judicial functions of the state were exclusively reserved for the judiciary, full stop. The only mention of the term tribunal, the only mention of the term tribunal, the only mention of the term tribunal was under Article 136, was under Article 136, stating that the Supreme Court can hear direct appeals under this section. Sorry, under this article, not section, under this article. Can hear direct appeal under this article from, SC can hear direct appeal under this article from any tribunal. From any tribunal. from under this article from any tribunal. Okay. Full stop. Change the paragraph. Change the paragraph. The need of tribunals, the need of tribunals, the need of tribunals was most acutely felt. Was most acutely felt. The need of tribunals was most acutely felt. Was most acutely felt with the rising pendency. With the rising pendency. With the rising pendency of cases before the Supreme Court and the High Court. Of the rising pendency of cases before the Supreme Court and the High Court. Rising pendency of cases before the Supreme Court and the High Court, comma. Law commissions in their report. Law commissions in their report. Law commissions in their report. In their report had raised alarm over these pendencies. Had raised alarm over these pendencies. And the solution of creating tribunals was being discussed. Full stop. In the 1970s, in the 1970s, with the creation of the Swaran Singh Committee, the idea of creating tribunals was first given effect by the 42nd Constitution Amendment 1976. The idea of creating tribunals was first given effect by the 42nd Constitution Amendment Act 1976. Was first given effect by the 42nd Constitution Amendment Act 1976. 42nd Constitution Amendment Act 1976. Okay. "42nd Constitution Amendment Act 1976. Okay. Which introduced Article 323A, and B. Which introduced Article 323A and B in the Constitution. Which introduced Article 323A and B in the Constitution. Which introduced Article 323A and B in the Constitution. Full stop. Next point. It is to be next paragraph. It is to be noted. It is to be noted that. It is to be noted that. It is to be noted that. It is to be noted that a motivation behind introducing tribunals. It is to be noted that a motivation behind introducing tribunals for the government was to was to was to diminute the power of judiciary, diminute the power of judiciary, diminute the power of judiciary in the diminute the power of judiciary in the diminute the power of judiciary in the in the tussle between the judiciary and the government, in the tussle between the judiciary and the government, in the tussle between the judiciary and the government, witnessed by cases such as cases such as Golaknath and Keshwananda Bharati, witnessed by cases such as Golaknath and Keshwananda Bharati. Full stop. Up to this date, up to this date, up to this date, up to this date, tribunals, up to this date, tribunals represent, up to this date, represent, up to this date, tribunals represent the ongoing tussle between the judiciary and the government, between the judiciary and the government on the question of on the questions of judicial review and independence of judiciary. On the questions of judicial review and independence of judiciary. On the questions of judicial review and independence of judiciary. Yes. Vishwaji, that is to answer your question. Contemporary time also it is high up to this date. That's what I'm writing over here. Right? Yes, we are seeing a battle between the judiciary and the government even today on the question of tribunals, and we'll take a look at what is happening in that regard. Okay, so this is the part of the first aspect of tribunals, original constitution. Okay. Now let's take a look at the 42nd Constitution Amendment Act. Okay, 42nd Constitution Amendment Act 1976. I'm just going to download a copy of the Constitution of India. Take a look at this. Tribunals, Article 323A and B, Part 14A of the Constitution. Okay. Now, we'll read this together. Article 323A, Tribunals. Just to give you a sense of this, okay, just let me explain you a little bit of the things before we can read it together. Okay. So, it was the introduction to the Constitution was Part 14A. And you had Article 323A and B. Article 323A specified the creation of administrative tribunals. And Article 323B specified the creation of other tribunals. Okay, this is what we are taking a look at. Part 14A, 323A, administrative tribunals and other tribunals. For example, let's say if you have let's say for example NGT, National Green Tribunal, or you have National Income Tax Tribunal, or you have Income Tax Appellate Tribunal, or you have let's say Customs Tribunal, or you have let's say Labor Tribunal. All of these tribunals are in other tribunal category. A specific category of tribunals was created for administrative tribunals. So for example, if you have the CAT, the Central Administrative Tribunal, this is under Article 323A. Okay, that's the point. How does this work? Let's take a look at it. Article 323A, what it did was, Article 323 empowered the Parliament of India under these two Article 323A and B to create individual tribunals by passing an act. So for example, if the Parliament has to create a CAT, it has to put the creation of CAT into a Central Administrative Tribunals Act, which is passed in 1985. Okay, so it has to pass an act of creating this tribunal, right? So the Parliament has to pass an act. Both the Lok Sabha and the Rajya Sabha have to create tribunals to pass an act, which is known as the Central Administrative Tribunal Act 1985. Okay, which underlines the fact that it is the Parliament who has been empowered to create a tribunal. Right, so all the tribunals which have been created under Article 323A, the Central Administrative Tribunal, and under Article 323B, NGT, National Income Tax Tribunal, Income Tax Appellate Tribunal, Customs Tribunal, Labor Tribunal, any kind of a tribunal is created by a corresponding act made by the Parliament. Right, so the Parliament amends the Constitution to give itself the power to create any tribunal which is going to be concerned with dealing with that subject matter. So for example, Central Administrative Tribunal created in 1985 is supposed to deal with the subject matter of administrative disputes. You see the point? That's what it says in Article 323A. In addition to that, Article 323A and B has a lot of provisions. I'm going to highlight the important ones. One of the provisions in Article 323A says that, and these are the same for 323A and B. Okay, let's call them the special provisions. It says that all the matters which are present with the High Court and the Supreme Court or any other judicial body in the country with regard to a tribunal which has been created will be transferred from that judicial body to the tribunal. Let's say, for example, if the High Court of Madras is hearing a matter on an administrative issue, let's say some IAS officer is found to be in some kind of a violation of the code of conduct and the matter has gone before the Madras High Court. What will happen after the passing of the act is that if the matter is settled by the Madras High Court, then nothing. But if the matter is still pending, it will be transferred from the Madras High Court to the CAT, and CAT will begin looking at the proceedings of it. Okay, it will be CAT which will be the defining authority, which will start with the proceedings of this kind of a thing. Okay, you get the point. So this says that all the cases will be transferred. Okay. Then what it said was, no appeal shall lie. No appeal shall lie from the judgment of a tribunal to a court, to a judicial, right? So if a tribunal, for example, has given a judgment, and then the judgment will not be appealed from the tribunal to the court, except in one case, that is Article 136. Except under Article 136, no appeal shall lie from an order of a tribunal to any court. Okay, and tribunals will have the exclusive jurisdiction upon their subject matters. Okay, you see, tribunals will have exclusive jurisdiction upon their subject matter. But the court cannot simultaneously also take up a matter which is being taken by the tribunal. Tribunal will have exclusive jurisdiction upon their subject matter. Right? Just take a look at these three conditions in reference to what I have made you draw over here. You see, this is the total judicial functions of the under the Constitution. By the 1976, these many functions, they have been stripped and taken away from the hands of the judiciary and given to quasi-judicial bodies known as tribunals. Right? This is exactly what we are looking at in Article 323A, that the ability of the judiciary to manage matters has been carved into half. Right? And a kind of a very clear separation has been created between matters which can be dealt by the tribunal and the judiciary, and matters which are going to be dealt by the tribunals shall not be trespassed by the judiciary. Okay, matters which have been created by the tribunals shall not be trespassed by the judiciary. You see the point? Okay, that is what was basically the concept of Article 323A and 323B. That's what is written over here. Okay, so take a look at this Article 323A. Please just take a read of this. This is with regard to administrative tribunals. Please take a look at this. Read this properly. You see, so Parliament may by law provide for the adjudication or trial of administrative tribunals. Right? Seen this? Now take a look at this. Take a look at these parts, that the Parliament can introduce these aspects in the law which it is making to set up a tribunal. Please take a look at Article 323A, Clause 1, D and E. Please take a look at these two. exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136 with respect to the disputes of complaints referred into Clause 1. It means that with regard to the administrative disputes, all jurisdictions are going to be excluded of all courts except under Article 136 of the Supreme Court, because it happened to be the case that 136 had the mention of tribunals to start with. Okay, 136 had the mention of tribunals to start with. Therefore, this kind of a situation is being taken into a direct description. Otherwise, the parliament would have made even 136 go away. Okay, then take a look at point number D over here. E, to provide for the transfer of to each such administrative tribunal of any cases pending before any court or any other authority immediately before the establishment of such tribunals, right? So you see all these points about point number A, B and C which had written, which had created a very separate watertight compartment between judiciary and tribunals, and judiciary cannot take up the cases back from tribunal at any cost, were given in the constitution under Article 323A and similarly under Article 323B. Okay, please take a look at Article 323B. Take a look at this part, please. Article 323B. Please take a look at this Article 323B. The matters which are referred to in clause 1, the other matters upon which tribunals can be created include levy, assessment, collection and enforcement of any tax, foreign exchange, industrial and labor disputes, land reforms, sealing on urban property, elections to either house of parliament, production, procurement, supply and distribution of foodstuff, rent, its regulation and control, offences against laws with respect to any of the matters specified in A to H, in fees, etc. Right? So almost everything, taxation, revenue, customs, environment, everything can be developed into a tribunal. But all these matters can be taken by the parliament, and it can be taken away from the Supreme Court and the High Court, and they can be given to bodies with our tribunals. Right. This also has point number D and E. Please read this point number D and E over here. What is given over here in point number D and E? Right, so same thing which is now these are the points essentially that we have to take a look at under Article 323A and B, that with this kind of a movement Article 323 and A and B ended up establishing the possibility of the parliament to create laws, to create tribunals by which powers of the Supreme Court and the High Court can be taken away and given to the alternate judicial bodies known as the tribunals. and thus the government of India could achieve a direct control over judicial functions, because the tribunals are created by the parliament and they are also to be appointed by the government, because parliament can make a law about the appointment of the members of the tribunals, right? So the government can appoint the members of tribunals. In a way, the government can directly control the activities of the tribunals, right? So this becomes the relevant part about the disputes that are going to be arising between the government and the judiciary with regard to this. As you can see that everything under this article has the very recipe of being challenged before the Supreme Court for the violation of the basic structure of independence of judiciary. Right? Supreme Court can very clearly say that if tribunals are going to look at matters from a judicial capacity, and if the members of the tribunals are going to be appointed by the executive or by the legislature, then it is a very clear cut textbook violation of independence of judiciary, because the members of tribunals will not be able to exercise their powers independent of the executive. So this is a recipe for a constitutional challenge. You have a idea of the basic structure doctrine, in which it is speaking about the fact that if any of the amendments made to the constitution, and this is an amendment made to the constitution, is in violation of the basic structure of the constitution, that amendment can be declared as unconstitutional by the Supreme Court under the case one of the Bharati judgment, right? So that's what basically is after having covered this part of tribunals, you know what I'm moving towards. What I'm moving towards is this third part of it, which is the judicial interpretation of things, right? We have judicial review and interpretation, in which you see a very clear understanding of how the tribunals are not going to be accepted very simply by the Supreme Court, and the Supreme Court is going to exercise some kind of a striking down of them. Okay, so let's just very simply take a look at the notes on this point number B. With point number B, please start writing the notes on this. We'll finish this quickly and try to finish at least till this part today. The 42nd Constitution Amendment Act 1976. Write down Article 323A and 323B. Please write this down. Write down the notes on this is what I mean. Please write down. Article 323 was divided into two parts. Article 323 was divided into two parts. Article 323 was divided into two parts. Was divided into two parts. Capital A, administrative tribunals, and B, other tribunals. Other tribunals. That is environment, taxation, customs, labor, industry, etc. Okay. Other tribunals, that is environment, taxation, customs, labor, industry, etc. Right? Clear? So you have a situation in which this kind of a thing has been given out. Okay, full stop. Right. Under these articles, the parliament has given the power to itself, under these articles. The parliament has given the power to itself to create tribunals in the above mentioned categories, to create tribunals in the above mentioned category. To create tribunals in the above mentioned category. To create tribunals in the above mentioned category. Create tribunals in the above mentioned category. To create tribunals in the above mentioned category. Above mentioned category. By passing a law. By passing a law. By space passing a law. Full stop. Okay. ठीक. Next paragraph change कर दीजिए. Just change the paragraph after this. In the law made by the parliament, in the law made by the parliament, in the law made by the parliament, it can specify that all the cases, it can specify that all the cases of it can specify that all the cases of that subject matter, all the cases of that subject matter, all the cases of that subject matter shall be transferred from any court in India, shall be transferred from any court in India to the tribunal, and all courts jurisdiction shall be excluded. 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 Shall be excluded. In all respects, except Article 136. In all respects except Article 136. In all respects except Article 136. Full stop. Okay. Next paragraph. These provisions of Article 323A and B, these provisions of Article 323A and B, can create an impression that the government is taking away the powers of the judiciary, taking away the powers of the judiciary, powers of the judiciary, powers of the judiciary by excluding judicial review, by excluding judicial review, by excluding judicial review upon the tribunals, by excluding judicial review upon the tribunals, by excluding judicial review upon the tribunals, and also the members of tribunals which are to be appointed by the central government under these acts, the members of tribunals which are to be appointed by the central government under these acts, the members of tribunals which are to be appointed by the central government under these acts, members of the tribunals which are to be appointed by the central government under these acts may bring a judicial function under executive control, may bring judicial functions under executive control, may bring judicial functions under executive control, comma, raising concerns about the independence of judiciary from the executive, raising concerns about the independence of judiciary, raising concerns about the independence of judiciary from the executive. Full stop. This has become the ongoing debate. This has become the ongoing debate. This has become the ongoing debate between the judiciary and the government. This has become the ongoing debate between judiciary and the government. Between the judiciary and the government, and has led to many constitutional challenges to the idea of tribunals, and has led to many constitutional challenges to the idea of tribunals. Led to many constitutional challenges to the idea of tribunals. Sir, can tribunals be made only on state level or only central level? Is there any SLA to create a tribunal? SLA, I'm assuming, is State Legislative Assembly. No. What Article 323A says is very clearly, simply given to you. Take a look at this, please. The act that you can create a tribunal with regard to any matter apart from administrative tribunal, the term which is written over here is the appropriate legislature. An appropriate legislature over here implies that even a state government, state legislative assembly, can create a tribunal upon the matters upon which it has, what you can say, jurisdiction. So, for example, if you have a matter of taxation, let's say indirect tax, if it is, let's say, under the control of the state government, under the state list of the 7th schedule, on that matter, appropriately the state legislature can create a tribunal. okay, with regard to Article 323B. So, what is given in Article 323B is a division between tribunals created by central government and state government, completely in correspondence to a seventh schedule, list 1 or list 2. So all of these matters, if they are forming a part of the state government, then the state will create a tribunal. And if they are forming a part of the central government, then the central government will create a tribunal. Because the term over here which is given is called appropriate legislature. But when we take a look at the administrative tribunals, it is very clearly mentioned that this tribunal can only be created by the parliament. Okay, you are seeing not the term appropriate legislature but parliament. Okay, does that help? I hope I am able to answer that question to some extent. Okay. Now, when we categorize Indian judiciary into three segments, SC at the top, followed by High Court and subordinate courts at district level, do tribunals come here in this categorization? No, that's the whole point. You're very good in answering, in asking that question. It's a very good question. You have what you call Supreme Court, High Court, and the district judiciary as what you can call the judicial bodies or judiciary, right? These are judicial bodies. Tribunals are what are called quasi-judicial bodies. And I'll explain to you the term of quasi-judicial bodies as to what is the meaning of the term. So they don't form part of this hierarchy. They are outside this hierarchy. They are semi-administrative bodies and semi-judicial bodies, only not completely judicial bodies. And I'll explain to you why they are called semi-administrative bodies, because they are under government control, unlike the judiciary which is independent. And as long as tribunals don't gain complete independence from the government, they will not be able to be called a judicial body, and thus they will not be able to be under the control of this hierarchy. So they don't lie under this hierarchy. In fact, this hierarchy itself has been ruled out by the provisions in the Article 323, which says that no jurisdiction can lie from any tribunal to any court. So this hierarchy has deliberately been excluded by Article 323A and B. Right? Does that answer your question? Nimai? Okay, so just let me give you a bit of a continuation of this, and then I'll probably naturally answer your questions that you're asking, Nimai and Anil, in what I'm covering later on with this one. Okay, so we've written about till this point. Okay, let's take a look at the third part of it. And talk about judicial review. That's exactly the discussion I'm going to have now, and judicial interpretation. Okay, we're going to take a look at cases with are going to be there. Okay, the first tribunal, after 1976, immediately after this reform was introduced, this amendment was introduced in the constitution in 1976. But immediately after that, in 1977, Indira Gandhi lost the elections, and then the Morarji Desai government came. Morarji Desai government did make many, changes to the constitution, but they reversed the changes to the constitution made by the 42nd Constitution Amendment Act, in the 43rd and 44th Constitution Amendment Act, but they did not reverse the tribunals part. There were some things which were being said that they were they did not have the requisite membership in the Rajya Sabha and all of these things. So they could not, 323A and B, they could not reverse. Okay, so it continued to be in the constitution. But after that, when Indira Gandhi came into power by 1980, she did not make any tribunals. She was kind of trying to make a peace deal with the judiciary at the time and did not want to fight so heavily with the judiciary. So it was in 1985, after the election of Rajiv Gandhi as the Prime Minister, that the first act under Article 323 A was passed, which is the Central Administrative Tribunals Act 1985. Okay, this was the first time a tribunal was instituted under Article 323A, 1985, the Central Administrative Tribunal, 1985. And within this thing, immediately as soon as this article was, as the act was understood, within a matter of 1-2 years, this act was challenged before the Supreme Court as being unconstitutional for two reasons. Number one, judicial review is barred, and number two, the appointment of the members of tribunals by the executive is hampering or defeating the concept of independence of judiciary. These were the arguments which were made before the Supreme Court. The name of the case is SP Sampath Kumar. Okay, this is what the name of the case is, SP Sampath Kumar case. And it was in this case that the tribunal reforms, tribunal Article 323 were called into question, stating that they were in violation of the basic structure doctrine because they violated two basic features: judicial review and independence of judiciary. Right. So this is the case by the name of SP Sampath Kumar, in which this was discussed for the first time. I'll just give you a sense of what it is. This is known as the SP Sampath Kumar case, SP Sampath Kumar versus Union of India. I have taken this judgment from the Supreme Court of India, 1987. Okay, so the first judgment, the first case that we discuss in this is SP Sampath Kumar versus Union of India. Now the point was this, that the question which was made by the Supreme Court before the government was this. Supreme Court, now look at this argument please. No? It's an interesting part that this kind of a discussion was happening between the Supreme Court and the government specifically. What the Supreme Court was saying to the government was that, tell us one thing, tribunals, what are they? What category of bodies are they? Okay. Question is, are they judicial bodies? Or are they executive bodies? Okay. So the idea was simply this, that they are judicial bodies by the virtue of the functions that they carry. Okay, they are deciding upon matters and giving judgments. So functionally speaking, they are judicial bodies. But let's say in terms of their institution, they were appointed by the executive, right? So the members of the tribunals are appointed by the executive. So with regard to the birth of these bodies, they are coming out of the executive. So what do we know? This is what is a quasi-judicial body, in which you have a bit of a complicated arrangement. A body which is coming out of the executive, meaning the members of the tribunals are being given birth by the executive. They're chosen by the executive, but they are performing, judicial functions. So Supreme Court says that what is it that you want to create? So the government said that we want to create an alternate system of judicial bodies, right? Alternate to high court, a kind of a high court which can be run by experts from that particular thing, right? So, for example, what the government said was, since you see, for example, the matters concerning environment and ecology. Okay. Now, with reference to the matters containing environment and ecology, what the government said was that you will see that the ideas with regard to environment and ecology are not being able to taken up by the High Court or the Supreme Court, specifically for a reason that they don't have the expert knowledge on these matters. They are not, environmental science, etc. So, a good idea would be to give the matters of environment and ecology to a expert body known as a tribunal, whose members are going to be appointed by the government and who will take judicial functions over the matters of environment and ecology. Okay, that's the point. So the Supreme Court said this fine. So you want to create alternate high courts, right? Let's say High Court of Environment and Ecology. The NGT that you call the National Green Tribunal is a High Court of Environment and Ecology, meaning that's exactly what you're trying to do. You're trying to create a specific body, people who have better brains than us to deal with environmental matters, who can have an expertise into it. Of course, we are lawyers and advocates and judges. We don't have an expertise in controlling what you call the environmental matters, right? But we don't have the expertise in understanding environmental matters. Fine, you do that. So the Supreme Court said, in that sense, it says that it upheld the point, it upheld the interpretation, which said that Supreme Court said that the position of Article 323A and B is completely valid. There is nothing unconstitutional about the Parliament creating a tribunal. So the Supreme Court dismissed the petition challenging the constitutionality of the tribunals. Okay, the Supreme Court said to the government that the constitutional validity of the tribunal is hereby established. We don't have any problem with regard to the tribunal being unconstitutional. But with this, Supreme Court very clearly said that if you want it to be a judicial body, it has to be purely a judicial body, right? Then it cannot be an administrative body at all. Okay, which means that the appointment of the members of the tribunal has to be done so that independence from executive can be maintained. Okay, and if that is not going to be done, then you know what happens? Then we will think of tribunals as administrative bodies. And if they are administrative bodies, then the High Court of a state would have a power or authority over the orders made by the tribunal under Article 226 and 227 of the Constitution, right? This is the argument that the Supreme Court gave. It said very clearly that if the appointment of the tribunals is not made independently in terms of make a committee or make a NCT, National Tribunals Commission kind of a thing, if the appointment of the members of the tribunals is going to be done by the executive, by the political masters, by the people who are running the government, then it will not be a judicial body, it will be an administrative body. And if it is an administrative body, then the provisions of Article 32 and Article 226, which are writ petitions, they will apply over the tribunals. So the Supreme Court kind of gave them a warning that you have written under Article 323A and B that exclude the jurisdiction of all the high courts. But that kind of a thing, we are agreed to do that. We can exclude our jurisdictions if tribunals are completely judicial bodies. Okay, but if the tribunals are not completely judicial bodies and they have an administrative feature to them, it will make them subject to Article 32 and Article 226 of the Constitution. This is given in the Constitution that any kind of let's say for example, if the order of a tribunal is breaking a person's fundamental right, then the order of the tribunal cannot be challenged before a Supreme Court or a High Court, because the law has been given under Article 323A and B like that. But a writ petition on that order can be filed, and therefore the High Court can exercise power of a tribunal, because the members of the tribunals are appointed in such a manner that it is a executive body, because it is not being appointed in the freedom of the executive. These are appointments which are made by the government, and the High Court has the right to do this kind of a thing. So the Supreme Court in this case, in the 1985 SP Sampath Kumar case, accepted the constitutional validity of the tribunals. Okay, it maintained that the tribunals are constitutionally a valid feature. The parliament has all the power to create tribunals, but if the tribunals have to exercise themselves as proper judicial bodies, then the appointment of the tribunals should be done by an independent procedure, neither influenced by the executive nor by the judiciary. Right? There must be a committee of people who should be responsible for giving the judgment as to who is the person who is fit to become a member of tribunal. If tribunals continue to remain, the court warned, under the hand of the executive in terms of appointment, then you can see why Supreme Court and High Court will take up orders of the tribunals and use the writ powers to control the tribunals under Article 32 and 226, because both these articles give the power to the Supreme Court to issue writs to any government department under the state if it is in violation of any of the fundamental rights. So the writ of mandamus, prohibition, quo warranto, certiorari, these are all writs which can be taken as an instrument by the High Court and the Supreme Court, and then it can review the judgments of the tribunals. So here the Supreme Court left the case with a good faith that the government will create an independent body by which the members of the tribunals can be elected, appointed, chosen, however, and the fact that the creation of tribunals as truly and purely legal bodies, judicial bodies, will eventually sit with the amendment properly. Then Article 323A and B, there's nothing wrong with them at all. The only thing which is sticking out here as a problem is that you are appointing the members of tribunals, and that is giving it an administrative shape. And if it continues to remain in this administrative shape, then we are going to object to the fact that it is a purely legal body, and if it is an administrative body, we will exercise control over it under Article 226 of the Constitution, Article 32 of the Constitution, by exercising the writ jurisdiction. This is what the argument of what you can call the Supreme Court was in front of the government, and that was the end of the SP Sampath Kumar versus Union of India 1950 case. Okay, you get the point? Right? Just take a look at this part. This is a document given by the Supreme Court of India judgment. It has given a kind of a nice introduction to the whole structure of tribunals. Take a look at this, please. Just once take a look at it. You see, exclusion of the jurisdiction of the High Court under Article 226 and 227 of the Constitution in service matters. Right? This is the challenge which was made before SP Sampath Kumar, that if it is No, if it is a judicial body, why is the appointment of the tribunal being done by the executive? And if the appointment of the tribunal are being done by the executive, it is an executive body. And then Article 226 and 227 of the High Court, the writ jurisdiction of the High Court will apply over the tribunal. Okay. So in SP Sampath Kumar, the Union of India held that the tribunal should be a real substitute of a high court, not only in form de jure, but also in content de facto. Right? That's the point. The point is that tribunals cannot be simply actions but appear to be as a judicial body, but actually should be judicial body in every form, which includes preservation of the independence of judiciary from the executive. Okay. So the central government was directed to make modifications to the Administrative Tribunals Acts pertaining to the composition of the tribunal to ensure selection of proper and competent people to the post of presiding officers and the things, right. So in that sense, the Supreme Court raised only one objection, that the appointment of the members has to be done by a independent procedure. Okay. Now, the next thing that we come to after what is known as the SP Sampath Kumar case, we've taken a look at cases, right? I'm just going to point it out again where we are in this entire thing. We are here, judicial review and interpretation, right? And in this, we've done the first case, which is the SP Sampath Kumar case, right? This is what we have understood with regard to the judgment of the Supreme Court. First. Second case, which is important, this is 1987. Second case, which is important, is known as the L. Chandra Kumar case. This is a case of Supreme Court in 1997. So in the L. Chandra Kumar case, now from 1987, when the Supreme Court had directed the government of India that please make the appointments of members of tribunals to be independent of the executive, make an independent procedure. You know, if you want, you can create an exam like the UPSC. For example, you have UPSC by which IAS officers are selected through an examination procedure. Similarly, you create a National Tribunals Commission on the basis of the Union Public Services Commission. You can create the National Tribunals Commission by which you have an exam and you have an interview board, etc., by which at the end of the day you have a set of people who can be appointed as members of tribunals, right? So the Supreme Court said that do something about making sure the appointment of the tribunals is independent of the executive influence, of the political influence. But the government of India had not taken any of these actions, and more tribunals were being created, but not any of those members were being appointed by an independent procedure. The government members, the organizations, the ministers, these are the people who are appointing the members of the tribunals. So in L. Chandra Kumar case, Supreme Court kind of got a little disturbed with this. 10 years had passed before its observations and nothing had happened. So Supreme Court then said in L. Chandra Kumar case that forget about the tribunals being a judicial body. You don't have a judicial body which is appointed by the executive. Tribunals are an executive body. Okay. Matlab, since the members of tribunals are being appointed by the executive, we will come to the conclusion that tribunals are an executive body, and therefore, just like any other executive body, the writ jurisdiction of Article 226 and 227 will apply before with the tribunal, which means that any order which is given by the tribunal can be appealed before a high court or even a Supreme Court if you can prove that it is in violation of fundamental right. Right, so L. Chandra Kumar case kind of lost its cool. The Supreme Court kind of lost its cool with the Parliament, not making any specific reforms in this matter. And then they say, can you do whatever you want? We will not agree with the reading of the SP Sampath Kumar case. So they said that tribunals are not substitutes. You see, that's what they said. They said that tribunals are not substitutes to high courts. because tribunals are not judicial bodies, they are administrative bodies. And just like every other administrative bodies, they have a ability to perform the functions of a judicial bodies, but these functions are going to be challenged before the High Court as a matter of a writ power of the High Court and the Supreme Court. So Article 226 and 227. This was a time under which the matters taken from the tribunals as an appeal can be given to the High Court and Supreme Court under the judgment made by the Supreme Court in L. Chandra Kumar versus Union of India 1997. Okay, just take a look at this part. You see, it kind of reversed the position of the SP Sampath Kumar case. L. Chandra Kumar versus Union of India. It completely reversed the position of the Sampath Kumar case and made this kind of a decision at the end of this entire thing. Just take a look at isko ek baar pad lijiye, read all of this. Just take about 2 minutes to read all of this. Okay. So this is the L. Chandra Kumar case in 1997. The court held that the power of judicial review vested in the high courts in this court under Article 226 and 27 and 32 is a part of the basic structure of the Constitution. Therefore, the court held that the tribunals cannot act as substitutes of the high court. You see? So, you see in the Sampath Kumar case, the Supreme Court had a different decision altogether. It said that tribunals should be a real substitute of the high court. Okay, and they had said that the central government directed to make modifications with regard to the composition of tribunals, giving a kind of opportunity to the government of India to convert them into completely judicial bodies. Okay, but since all these years had passed and no such decision was taken by the government of India, the Supreme Court itself overruled its previous decision and said that the tribunals cannot act as substitutes of the High Court, because they are not judicial bodies, they are administrative bodies, because their appointment are done by administrative officers and their functioning is only supplementary, and that all decisions of administrative tribunals will be subject to scrutiny before a division bench of the respective high courts. Right? This is the answer to the question that you're asking. Right? Addressing the issue of the dependence of tribunals on the executive for administrative requirements, a recommendation was made for creation of single umbrella organization which will be an independent supervisory body to oversee the working of the tribunals. Okay, so they said that since you are going to keep it with yourself, please organize it properly so that it is becoming easier for everyone to understand how this kind of an activity can be taken up. You see the point? So this is where the whole idea about the initial areas of tribunals in terms of the what we have done is we've moved from 1976 to 1997 with regard to covering all the aspects of the tribunals. Okay. SP Sampath Kumar. This case we have understood, and then we are taking a look at what is known as L. Chandra Kumar. These are two landmark judgments, and by the end of the landmark judgment of L. Chandra Kumar, the appeal from tribunals can be made before the high courts. Right? And Article 226 and Article 227 and Article 32 also leaves the scope for any judgment of the tribunal to be taken up to the high court. This was the L. Chandra Kumar. So today, for example, recently there was a judgment. I'll tell you, for example, this is something that you can personally relate to. After the the eventful UPSC prelims examination that this time came, a lot of people had gone to the Central Administrative Tribunal to file a case against the UPSC, stating that it is playing with people's life and sentiments. How can you give an exam like this, which is CSAT is uncrackable and it is favoring the mathematical students, all of that. So after this was decided by the CAT had rejected the this is a kind of a case that we can take a look at in a but as it is moving kind of a way. So here is a point about it. After the examination, 2023 prelims examination, students had gone to the Central Administrative Tribunal seeking a reduction in the qualifying cutoff for the CSAT paper. They argue that the difficulty level is comparable to CAT and IIT JEE exam. The matter will be heard by the tribunal. Right? The tribunal heard the matter, and the tribunal finally disposed the matter off, saying there is no such problem with this. It is perfectly all right. Don't act too smart. Simply prepare for the next attempt. Right? So tribunal ने झाड़ो के फेंक दिया बच्चों को बाहर. ठीक है. Then these people went to the High Court of Delhi. The whole idea about the fact that they can appeal to the High Court of Delhi. Okay, take a look at this. The plea was a part of petition filed by 17 aspirants seeking the answer key of the preliminary examination held earlier this year. In fresh plea, the aspirants urged the High Court to stay the UPSC's invitation for application for the main examination, saying otherwise the main petition will become pointless. The petition said it has been UPSC strategy in the past to get court cases dismissed on account of passage of time. Okay, so the plea stated that there were many questions in the preliminary examination of 2023 where there are two possible answers, but UPSC in its own discretion decides one of them as correct answer and marks the candidates accordingly. So this kind of a petition had gone to the Delhi High Court, but the Delhi High Court refused to stay the main examination before deciding the plea. And the point that I'm trying to make is that it is supposed to be with regard to the fact that the CAT, the Central Administrative Tribunal, can pass an order which can be appealed before the Delhi High Court today, currently. That is the case. And the source of that understanding is the L. Chandra Kumar case. Okay, that is what we're taking a look at. Clear? So let me just, in the time which is remaining, give you a set of answer. Let's write something about this third part before we wrap up for today. The SP Sampath Kumar case and the L. Chandra Kumar case, and the whole question whether a appeal can be taken to the tribunal or not be taken to the tribunal. Okay, let's start. Judicial review and interpretation में write down. Just write an introduction first. Point number C के नीचे लिखना शुरू करिए. Just write an introduction under point number C. An introduction under point number C. Write down. In SP Sampath Kumar. Sorry, don't write SP Sampath Kumar. Just write down this part which I'm saying over here. The first enactment made by the parliament to constitute a tribunal. The first enactment made by the parliament to constitute a tribunal. The first enactment made by the parliament to constitute a tribunal. The first enactment made by the parliament to constitute a tribunal was the CAT, Central Administrative Tribunal Act 1985. 1985, which provided for 1985, which provided for the creation of administrative tribunal, which provided for the creation of administrative tribunal, which provided for the creation of administrative tribunal, and the transfer of administrative matters from the High Court and Supreme Court, transfer of administrative matters from High Court and Supreme Court to the CAT, and no appeals from the order of the CAT. No appeals from the order of the CAT. And no appeals from the order of the CAT. And no appeals from the order of the CAT. Okay, full stop. Okay, next point. Next paragraph, write down. In SP Sampath Kumar versus Union of India, in SP Sampath Kumar versus Union of India, in SP Sampath Kumar versus Union of India, SP Sampath Kumar versus Union of India, this act was challenged. This act was challenged along with Article 323A and B. Along with Article 323A and B, as being violative of the basic structure, as being violative of basic features, as being violative of basic features, as being violative of basic features, like independence of judiciary, like independence of judiciary and judicial review. Independence of judiciary and judicial review. Full stop. The Supreme Court in this case, observed that, that the Parliament has the power. The Parliament has the power. Observe that the Parliament has the power. Parliament has the power to. The Parliament has the power to The Parliament has the power to create the alternate judicial system of the tribunals. To create the alternate judicial system of the tribunals. To create the alternate judicial system of the tribunals. To create the alternate judicial system of the tribunals. But they must be truly judicial in nature. They must be truly judicial in nature. Judicial in nature. To substitute the high courts. To substitute the high courts. They must be truly judicial in nature to substitute the high courts. Truly judicial in nature to substitute the high courts. Full stop. Thus, the constitutional validity of 323A and B was established. Thus, the constitutional validity of 323A and B was established. Constitutional validity of 323A and B was established. But government was given directions. Government was given directions for making the composition of the members of tribunals, based on merit and character. And free from executive influence. Merit and character and free from executive influence. Merit and character and free from executive influence. Free from executive influence. Comma. To ensure not only a de jure here, this is the point. To not only a de jure, but in content and de facto, but not only on paper but in reality. De jure but in content and de facto, judicial nature of tribunals. Judicial nature of tribunals. Judicial nature of tribunals. Full stop. Okay, this is the SP Sampath Kumar case. Okay. Okay, chal, I will break now. Tomorrow I'll give you the dictation on L. Chandra Kumar and then finish up very quickly, the last part of tribunals, which is about the current happenings in tribunals with regard to what is happening in the Supreme Court of India with regard to the Tribunal Reforms Act and what is the status of the National Tribunals Commission, NTC, etc. Quickly we'll cover this and we'll try to cover all the remaining topics tomorrow for governance to make a kind of a attempt to concluding all of this entirely. All right. Thank you for your time and patience. Let me see if there are questions here. So, I think Anil, I answered a question with regard to the division bench. Right? A division bench is where what the High Court of the Supreme Court said in Al Chandra Kumar case. We read this. According to SC, Nimai question, everything in India is under the judicial review, but Article 323 says that judicial review is not applicable on tribunals. So tribunals not coming under judicial review is absolute. Oh, first of all, there's no such principle or fact that everything under in India is under judicial review. So many things in the constitution have been very clearly kept outside judicial review, right? There are many things in the constitution which are kept outside judicial review. For example, interstate water disputes is kept outside judicial review. So there's no such assumption that everything is under the judicial review. And if the parliament, which has the constituent powers same as the constituent assembly, wants to exclude judiciary from having a review upon certain things, it is permissible. It is not completely invalid to do that. It depends upon what is the subject matter. If that subject matter is a basic structure of the Indian constitution, a basic feature of the Indian constitution, then the judiciary may strike it down. You see the point? So by default, it doesn't come to a position that judicial review is not something that can never be exercised. The parliament wants, you see, in 10th schedule, the decision of the speaker is not under judicial review. The decision of the speaker with regard to money bill is not under judicial review. Many of the actions done by the president of India under powers which are given to him with regard to pardon are not under judicial review. So many exceptions to what the judicial review is. There's no such assumption that there's a kind of a blanket power given to the judiciary to review everything. Okay, Anil has another question. Are these courts bound by the code or CPC or an Indian Evidence Act? Yes, 100%. Of course, they are judicial bodies. They are conducting judicial functions, and they have to, for example, if a court is registering witnesses or evidences, it can only do it through the Evidence Act. They cannot do it through anyone else. Okay. How should I discuss the Indian Evidence Act? Well, it will take a long time for me to discuss the Indian Evidence Act. It's a huge thing. Please ask me a more specific question. Maybe I can target that question. Why SC wait for 10 years? Why not SC take the case suo motu at the time of amendment? Well, it did not wait for 10 years. Hold on. The amendment gives the power to the parliament to create a law. If the parliament is not creating a law, what can the SC do till that time? Right? But the act has to be enforced. So the first time the parliament had actually created a law was in 1985, and in 1987 the Supreme Court acted on it. Right? It's better for the Supreme Court to declare once you can demonstrate that it is not working, then you can say that we are able to challenge it, but abhi to demonstration tha hi na ki it is not working. They obviously got the solid ground of it is not working only when this act was passed. You see the point? So that they were waiting for this particular thing to become an act, the application of Article 323, right? And all said and done, the last, all these 1976 to 1984 were such difficult years for India. You had the end of emergency, elections of 1977, 43rd, 44th Constitution Amendment Act, again the election of Indira Gandhi, then the death of Indira Gandhi. The Supreme Court was in a way trying to keep itself distanced from the political actions. In 1987, the Supreme Court found a sweet spot where it could deal with these things, so that it took control of these things more easily. So there is a sociological and historical aspect also to some of these decisions. Okay. All right. Okay. Thank you for your time and patience. I will see you tomorrow. Thank you.